Dear friends, in this unit, we will be looking at social legislations and constitutional provisions in favour of children. Child is the father of man. This is an aphorism that correctly represents the importance of children in our society. In order to improve the conditions of children, the government and legislatures have taken several measures from time to time to bring in provisions and statutes that provide some help to children. Children are not only a source of immense joy to us all. Children are also the greatest resources of any society. Children are the individuals, the citizens of tomorrow. Children hold the key to a great future. It is not only our duty to give an enjoyable childhood to children, it is also our duty to make sure that they grow up as responsible and capable citizens. The Indian Constitution recognizes the special needs and the special place of children in the society. We will now look at some of the major constitutional provisions and legislations which seek to protect and improve the conditions of life of children. The constitutional provisions that seek to protect our young citizens are as follows. Article 15 is a provision that is within the Fundamental Rights chapter of the Constitution of India. The fundamental right that is guaranteed under this provision is that of non-discrimination by the state. Article 15(3) provides that within this broader principle of non-discrimination, special provisions may be made in favour of children, wherein they may be treated differently from other citizens. This shows that it is the intent of the Constitution that children are to be recognized as different from rest of the society, and unless special provisions are made for them in some respects, it amounts to discrimination against them. The 86th Amendment of the Constitution of India brought about in 2002 a new right within the scope of the fundamental rights already available to citizens. This fundamental right, incorporated in Article 21A of the Constitution of India, is important here because it is available specially for children between 6 and 14 years of age. This is the right to free and compulsory education. This has been brought into force by the Right to Free and Compulsory Education Act of 2009, which came into force in 2010, about which we shall be discussing in a separate chapter. Article 24 is part of the right against exploitation guaranteed by the Constitution of India. It provides that children below 14 years of age shall not be employed in hazardous employment. This provision is bolstered by another in the chapter on directive principles of state policy. Of the Constitution gives a direction to the state that it should endeavour to ensure that no child is forced by economic circumstances to enter into avocations that are not suited to his age or to his physical and mental strength. This is operationalized by the government in several ways. On the one hand, laws are passed which make child labour illegal, and there is a mechanism that has been set up to check any instance of child labour. On the other hand, educational programs are so set up that they are combined with incentives such as the midday meal scheme, whereby school going children are provided with a hot cooked meal. The next provision, Article 39F, ties into this intention beautifully. According to this provision, the state is required to ensure that the health and dignity of the child are protected. Whereas the education of children between 6 and 14 is a fundamental right, the care and education of children below 6 is covered within the directive principles of state policy by Article 45. We may also look at the group of exhortations to the citizens that is contained in the Constitution, that is, the fundamental duties. Article 51A(k) of the Constitution of India is the provision which is relevant here. It is the duty of every citizen who is a parent, a guardian of a child between the ages of 6 and 14 should provide the child with opportunities for education. We see that the three important parts of our Constitution, the fundamental rights, the directive principles of state policy, and fundamental duties, all contain within them provisions specially for the protection and care of children. It therefore becomes very clear that it is the express intention of the Constitution makers that the child should be treated with greatest love and care. While the Constitution gives the broad framework and the directions the country should take with respect to the treatment of children, it is through several legislations that these goals are realized. We shall now look at various provisions and legislations which are relevant in this regard. The primary criminal legislation for affixing liability in India is the Indian Penal Code. According to section 82 of the Indian Penal Code, no act done by a child of less than 7 years of age is an offence. This reflects the understanding that children, especially children below 7 years of age, are not capable of understanding the true nature and consequences of their acts. Section 83 says that when a child between ages of 7 and 12 commits any act, it will not be an offence if the child is not capable of understanding the nature of its acts. The legal system has, however, gone further than the Indian Penal Code, which was drafted in the mid-19th century. Today, juvenile offenders are dealt with under the Juvenile Justice Act. Why do we need a separate legislation for children? The answer is simple. Children are not people, children are not individuals who have attained sufficient maturity of mind. Children are wanting in their exposure to the realities of life, and they may be swayed toward committing acts which they do not truly intend. Far more importantly, the criminal correctional system might often turn these same children towards directions which they would not have taken had they been treated not as fully grown men, but as children. Therefore, the Juvenile Justice Act serves as a very important step to ensure that children, whatever mistakes they commit, are treated only as children. The Juvenile Justice Act is an important piece of legislation for children. According to this legislation, when it is found that the person who has committed an offence is below 18 years of age, he has to be brought before the Juvenile Justice Board and not the regular courts. In case he is brought before a regular magistrate, he has to be redirected to be brought before the Juvenile Justice Board. The Act further lays down the various details that should govern the treatment of a child in conflict with the law, so as to sensitize the legal system to the special needs of the children. The Juvenile Justice Act brings the law in India in line with its obligations under the international agreements, such as the International Covenant on Civil and Political Rights, by providing that no person under 18 years of age shall be punished with death sentence and life imprisonment as per section 16 of the Act. The Act also lays down certain special offences under section 20 to 26, which include offences like disclosing the name of juvenile offenders, treating juveniles cruelly, giving narcotic drugs to juveniles, and exploitation of juveniles, etc. Further, the Act comprehensively lays down a full-fledged support system and also details the way in which it will take decisions. This support system will identify children in need of care and protection. The Child Welfare Committee has been empowered to take decisions on their behalf and also later take care of rehabilitation of the child and reintegration into society. One of the most pervasive evils in our society is that of child marriage. The social customs in several communities across the country dictates that the children be married off at a very early age, and this early marriage often extends to marrying of children before they reach an appropriate age. This practice was countered by the Restraint of Child Marriage Act of 1929. The Act provides that a male has to be at least 21 years of age and the female has to be at least 18 years of age to be of marriageable age. Child marriage is also made a punishable offence, and it is an offence not only to be the person for solemnizing the offence, but the parents and the groom, if he is above 18 years of age, is liable. The Child Marriage Prohibition Act of 2006 has only bolstered this position, while at the same time making provisions for clearing any confusions and problems that may arise from observing the provisions of the Act. We now move on to our next legislation. It is the Infant Milk Substitutes Act. The Infant Milk Substitutes Act of 1993 and 2003 make an intervention in a highly specific but very important area of child care. This pertains to the feeding of the child in its early stages of infancy. Here, we may see the special degree of care that children get as consumers. The Act lays down several warnings that are required to be carried by the infant supplement food products. They are also to make provisions for natural breastfeeding of the infant, which has been determined to be best for the health of the child. It also requires the government to provide adequate information to people regarding the superiority of breast milk and especially colostrum, which is the milk secreted within the first week of delivery. It is a rare example of a statute whereby medical and scientific information is detailed in the legislation itself. Another social evil in India is that of female feticide, which has also skewed our sex ratio to an unacceptable degree. Though the legislatures have attempted to combat this with several legislative measures, it has not been to much effect. Perhaps the most important legislation in this regard is the Preconception and Prenatal Diagnostic Techniques, or the Prevention of Sex Selection Act. This legislation makes it an offence to employ the use of ultrasound and other techniques to determine the gender of the child. You might ask, how does that change the grave issue of female infanticide? You might also ask, what has been the success in stopping these practices? This practice of female infanticide continues to be perhaps the biggest blot on India's development story. It is not only a blot because of its mere existence, it is a blot because of its persistence. What is far more important is the fact that this practice is prevalent not only amongst the illiterate or the backward sections of the society, but it is a practice widely prevalent even amongst the advanced sections of society. This tells us that the problem is not only economic, it is a deep-rooted malaise. It is a deep-rooted malady which needs to be corrected post haste, or we might be moving on to a society which does not respect its girls, its females in any form except as statues. We will now look at the functioning of the National Commission for Protection of Child Rights. The National Commission for Protection of Child Rights has been set up under the Commissions for Protection of Child Rights Act 2005 and has been in operation since March of 2007. The following are the duties of the Commission. First, the Commission shall perform all or any of the following functions, namely, first, to examine and review the safeguards provided by or under any law for the time being in force for the protection of child rights and recommend measures for their effective implementation. Second, it shall present to the centre government annually and at such other intervals as the Commission may deem fit reports upon the working of the safeguards mentioned in the first point. Thirdly, it must inquire into violation of child rights and recommend initiation of proceedings in such cases. Fourthly, it must examine all factors that inhibit the enjoyment of rights of children affected by terrorism, communal violence, riots, natural disasters, domestic violence, HIV/AIDS, trafficking, maltreatment, torture and exploitation, pornography and prostitution, and recommend appropriate remedial measures. It must also look into matters relating to children in need of special care and protection, including children in distress, marginalized and disadvantaged children, children in conflict with law, juveniles, children without family, and children of prisoners, and recommend appropriate remedial measures. It must also study treaties and other international instruments and undertake periodic review of existing policies, programs and other activities on child rights and make recommendations for their effective implementation in the best interest of children. It must also undertake and promote research in the field of child rights. It must spread child rights literacy among various sections of society and promote awareness of the safeguards available for protection of these rights through publications, media, seminars and other available means. Next, to inspect or cause to be inspected any juvenile custodial home or any other place of residence or institution meant for children under the control of the central government or any state government or any other authority, including any institution run by a social organization where children are detained or lodged for the purpose of treatment, reformation or protection, and take up with these authorities for remedial action if found necessary. Next, to inquire into complaints and take up suo motu notice of matters related to deprivation and violation of child rights, non-implementation of laws providing for protection and development of children, non-compliance of policy decisions, guidelines or instructions aimed at mitigating hardships to and ensuring welfare of the children and to provide relief to such children or take up the issues arising out of such matters with appropriate authorities. Such other functions as it may consider necessary for the promotion of child rights and any other matter incidental to the above functions. After having taken a detailed view of the functions of the Commission, we can say that it has been given a very broad mandate. However, it is also true that the resources available to this Commission do not match the sweep of its duties. There is a need of further strengthening the Commission if it is to be found effective in the duties assigned to it. The right to education, which, as we discussed before, has been guaranteed by the 86th Amendment to the Constitution of India, and it has been operationalized by the Right to Education Act of 2009, the Right of Children to Free and Compulsory Education Act, which has come into effect from the April of 2010. This is viewed as a landmark legislation which will go a long way in ensuring that all children in the country will have access to quality education. We will look at the details of this legislation in a later chapter. The phrase demographic dividend, which is used with reference to the larger percentage of young persons in our country, probably tells us more than what is evident at a first glance. While it does tell us about the increased earning potential in the years to come, thanks to the young population, it also shows that the young ones of our country are a veritable asset to the country. Any businessman worth his salt would agree that an asset is valuable only when it is protected and developed to reach its potential. This then makes evident the need to take care of the children's welfare. While the steps taken so far have been encouraging, there is a long way to go, as can be seen from the various human development indicators. 48% of the children in our country are malnourished and a similar percentage of children are stunted. This should serve as an alarm bell for us, and the issue of children's welfare has to be taken up on a war footing.